Hey, everybody. Welcome in. The question on everybody's mind is whether or not Karmelo Anthony's attorney did anything. People believe he did absolutely nothing. We've heard that he made no objections. We heard that he didn't subpoena any expert witnesses. We heard that he didn't prep his witnesses. So here's the question, and we're going to figure it out today. I'm going to walk you through the court records. I'm going to show you who filed for what, who applied for what the judge granted, what the judge did not grant. And then I'm going to let you guys decide for yourselves. I'm going to tell you everything that I see. I'm going to tell you what it means. I'm going to tell you likely why I think they did it, and then you guys can decide for yourselves. All right, so the first thing we're going to do is we are going to go to we're going to go actually to the court's website. In the meantime, you guys, welcome in. My name is Gray. This is my channel, Counsel Gray. What I'm about to do right now is walk you through. I'm about to walk you guys through the actual court docket going back to the beginning, the pre-trial era of Karmelo's case, because a lot of people think that his attorney did absolutely nothing. I'm going to say I have looked at it, and there are some key things that I see that he did not do, but he did not do absolutely nothing. He certainly tried a number of things, and it looks like he may it looks like he may have gotten shot down on a few things. So give me 1 second, and I'm going to pull up his entire case for you guys. By the way, you guys, if you're new here, welcome. If you're not, like, chat, subscribe, super chat. Thanks to everyone who has supported the channel all this time. I appreciate you guys. All right, so while I am pulling this up, what I can tell you is that his attorney did do a number of things. He did attempt to do a number of things. And you're going to see that some of them were successful and some of them were not. You're also going to see what the prosecutor attempted to do, and that the defense clearly did not do. One of the things that you're going to see is that the prosecutor did petition the court to enter expert witnesses, and there's no indication that the defense attempted to enter expert witnesses. All right. Okay, you guys. So what we're looking at right here is we are in the Collin County Judicial Online Search, and we're going to go line by line through his entire docket. So thank you for sticking with me. That was a minor technical difficulty. And we're going to look back. If you're looking right here, April 2nd, 2025, that was the day that he was arrested. Okay. So then there's a letter of representation. So the letter of representation, which is right here, this is what the defense would have filed to let the court know that he had an attorney. That attorney then ultimately left. And if you remember back then, they went through a number of attorneys. You see on June 25th of last year, they had a new attorney, a new letter of representation. On that same day, they filed to say that he was indigent, right? And that he was eligible for a court-appointed attorney. He was eligible for the public defender's office or a court-appointed attorney, which sometimes are the same, sometimes they're not. Now, if you look right here, late June of last year, the defense did apply to subpoena something. We don't know what they applied to subpoena, but they did subpoena something. Now, if we go to the next page, we can see two more applications for subpoena. So that's four applications for subpoena in total, and then we see 4 subpoenas approved or issued. Now, this would have been the second attorney. And if you saw my video, why Karmelo's team keeps changing, you'll see who these attorneys were. One of them was Derek Walpole. He put in a lot of subpoenas to get the case rolling, if you remember. So then here's another letter of representation. So I'm assuming that this is when Mike Howard got onto the case, unless we see another letter of appearance. Okay, so on the 18th, and now we're about 3 months and 2 weeks after the event, you can see that a gag order was issued in the case. Okay, so let's keep going. Now, here's something interesting that I don't remember what this was. If anybody remembers what this was, let me know. On July 28th of last year, there was a motion for a protective order regarding FERPA protected information. I don't remember that. And then we have John Doe's unopposed motion for a protective order. And then the next day, the protective order was issued. Does anybody remember who got that protective order? That was after they had already moved. So I don't know who that could have been. Hold on. You guys, thank you for bearing with me. I am still a new YouTuber trying to figure it out. But yeah, I don't remember this protective order, but okay. And then a week later, there was a motion to withdraw the motion for protective order. I don't know. A proposed order granting motion to withdraw the motion for protective order. John Doe's motion. I don't know who the John Doe is. John Doe's motion to withdraw the protective order, and then the order granting motion to withdraw unopposed. All right. So then again, we see now at this point, Mike Howard is on the case, right? So here's a defense motion for subpoena. Again, it's blank, so we don't know who or what they tried to subpoena. A second attempt for subpoena, a third. So now this is subpoena attempts by the defense 5 through 7. So we can't say that they did nothing. We don't know what they tried to subpoena. It could have been people, it could have been records, it could have been documents, it could have been footage from the school. We don't know. All right, keeping going. So now we're about to jump in this year. Now, wait a minute. Hold on. Right here, we see 3 requests for a subpoena, but we see only 2 that were granted here. So I don't know. We won't know what third one was not granted here. Maybe I don't know when we'll find that out. It probably would not be, it definitely would not be in the trial transcripts, but the record may come out later, but you'll notice that 2 of the 3 were granted. The last time when we saw the defense make 4 subpoenas, 4 subpoenas were approved immediately. Okay, so nothing happens between the end of December and the end of January. The next thing we see, the state's notice of discovery tendered. Now, this is interesting. Let's see. So nothing happens for another 2 months, and then we see consecutive subpoenas by the state, all filled out on the same day, right? 1, 2, 3, 4, 5, 6, 7 applications by the state for a subpoena. Let's see if there's any more. 8, 9, 10, 11, 12, 13, 14, 15, 16, 17 subpoenas by the state. All right, let me count those again. So from the defense, we saw 7 subpoenas. 6 of them appear to have been granted. I'm going to recount the state subpoenas, okay? 1, 2, 3, 4, 5, 6, 7. Moving on. 8, 9, 10, 11, 12, 13, 14, 15, 16, 17 state subpoenas. 18, 19, 20, 21, 22, 23, 24, 25, 26, 27, 28, 29, 30, 31. So to the defense's 7 subpoenas, applications for subpoenas, we see whatever number I just got to, 31, 32 state applications for subpoenas, and they're not done. Okay, so then on April 16th of 2026, we see the order regulating trial proceedings, media access, security, and the courtroom decorum. I believe that this would have come from the judge. This is what he was talking about, how he worked on this for eight months, perhaps more than 8 months, before the trial actually happened. So this would have come 2 months before, once they probably set the date, but it had been going on. He said that he worked on it for 8 months. So he probably had been working on it long before this order came out, which sort of captured the final rules and regulations, right? So after that, the defense makes another request for a subpoena. So this is Mike Howard again. The state makes an application for a subpoena, granted. The state makes another application for a subpoena, granted. So now this is the second defense subpoena that doesn't appear to have been granted. Now, we don't know, again, all of these are blank, who these subpoenas are for. We don't know if they're for minors. We don't know if they're for court records, for footage. We don't know if this is for fingerprints. We don't know anything about what it's for. But again, this is the second defense subpoena that does not appear to have been granted, whereas every state subpoena has been granted. Okay, so now the state makes another application for subpoena. Several subpoenas here are granted. And I want to take you back. So right now we're on number 71 through 80. If you go back here, all of these state subpoenas where they weren't immediately granted, let's see if they start getting granted now. Okay, subpoena, right? Another defense application for subpoena, right? So this guy is not doing nothing, but of course we don't know what these subpoenas are. More state subpoenas, but they are literally outnumbering. They are outnumbering the defense 3 to 4-fold, right? 3 to 4-fold, they are outnumbering the defense. All right, let's keep going. Oh, wait, hold on. Let me see. What was that? Oh, defense application for subpoena again right there. So he's not doing nothing. Here's a bunch of subpoenas granted. We don't know whose they are. Could be defense, could be the state. We don't know. There's another wall of subpoenas. All right, so now let's get into this. Okay, so now we're getting really close to the trial time. Okay, correspondence. Supplemental notice of media attendance and request for post-trial exhibits. That means this is a letter to the court, most likely. Here's a request for disclosure of experts. Now, most likely, this is the state requesting the disclosure of expert witnesses from the defense. And the reason I say most likely is because it all seems to be in one filing, right? So at the same time that the state disclosed its own expert witnesses and its own witness list, it would have requested from the defense their list of experts. State requests another subpoena. A subpoena is granted. In order appointing a public information officer, this would have come from the court. The court would have amended this order from before, where they were talking about the rules of how the proceeding would go, how the media would have access, what the security in the courtroom decorum would be, right? So that order was amended. Another state application for subpoena. Another subpoena granted. Subpoena return, that could be ones that were returned in the mail or something like that, or were never properly delivered on the person who was being subpoenaed. Okay, we're getting really close to trial time now. These subpoenas may be recorded as non-deliverable, or they could have been for non-witness subpoenas, right? That people may have submitted something that was not a witness. It could have been a document. It could have been an interrogatory. It could have been anything. All right. Now here is an affidavit of no record. So what this is going to mean is that, again, it doesn't tell who did it. This is going to be someone attesting that they have no records, right? Whatever was subpoenaed from them, they're saying here they don't have it. They're swearing to the court that I don't have whatever I was subpoenaed for. Another state subpoena and the defense, another defense application for subpoena. So it just occurred to me, some people may not know what a subpoena is. A subpoena is a court-approved demand for someone to do something or be somewhere, or to hand over something, right? This is basically the court agreeing with the party that this information is important, and the court is saying that on behalf of the parties, you have to turn this information over. It's relevant to the trial. We need whatever's in your possession, whether it's your live testimony, whether it's records in your possession, right? This is a subpoena is a demand to appear or to produce or to show something. An affidavit of no records would be someone whose records were subpoenaed. They're basically saying, we don't have the thing, and we're attesting to the fact that we don't have the thing, right? We have no records, right? But an affidavit is a sworn statement. All right, so let's keep going. This is, if you just got here, we are going through the Karmelo Anthony docket. This is the trial court. We're going to go through the appellate docket in a minute so you can see exactly what the appellate court has done. And we're right here. We're within the week. Now, this is interesting, okay? We are within the week of when the trial is starting, and now we're starting to see some defense subpoenas approved. So if you are wondering why the defense maybe wasn't familiar with all of its witnesses, it could be because these subpoenas were not approved until the week before trial. I don't know. We can't see over here. We can't see what these subpoenas were for, or who or to whom they were given. We can't see that, so we don't know. All right. So we're within a week of trial, and just to bring people up to speed, if you weren't here before, in the very, very beginning, the defense put in a number of subpoenas, and they were granted. Then their attorney transferred to Mike Howard, because Mike Howard was actually the third attorney that entered on this case. The subpoenas were created by the second. Now, if you remember back then, that attorney, I believe, was Derek Walpole. If you haven't seen my video about why his team keeps changing, go back and look at that. And I tell the role that Derek Walpole did. When he came, before that, there were two lawyers on the case, two sort of prominent civil rights attorneys, local, on the case. They didn't really get it moving very quickly. They got fired. They picked up this guy, Mike Walpole. The very first thing that Mike Walpole did when he came into office was he fired off a bunch of subpoenas. He fired off 7 subpoenas. I think we saw that 6 of them were granted. The 7th one was not granted, but we don't know what any of them were. Then Mike Howard picks up the case. And the prosecutor then fires off, you guys, what was that number? Like 30-something subpoenas? By the time he was finished, he was maybe up to 40, low 40s, 41, 42 subpoenas. And from what we can see, it looks like they were all granted. Mike Howard was very slow, according to this timeline. He was very slow to put in his applications for subpoena. And even with those, one of his was not granted. Now we're 1 week before the trial starts on May 26th. And we can see that now the defense is firing off these subpoenas. Again, we don't know to whom, about what. Was it records, documents? Was it testimony? But it certainly is not leaving much time to review whatever the subpoena elicits. So if these were witness subpoenas, like as in you being subpoenaed to appear in court and testify, there's no time to prep the witnesses. There's no time to interview them. There's nothing. If this is documents or video footage, there's just not enough time, right? And someone had asked in one of the comments, like, why, if the defense wasn't ready, why didn't they request an extension? Or if late evidence was provided to them, why didn't they get an extension? And the answer is, I don't know. But if I had to guess, I would say that it was because The judge, he did a lot of legwork to set this up. He had to get law enforcement at the county level, law enforcement at the state level. They had to reschedule a lot of people's trials. The other judges in that courthouse, they had to conduct their trials by Zoom. So the closer they got to the trial date, the harder it would have been to move that trial date, right? So if he just got this information the week before and it was like impossible to change the court date because of all the people, right, the media, right, everybody had already made their arrangements, he didn't have enough time to deal with this information. All right, so let's see. Okay, so we're still, let me just make sure that these pages are actually changing. That's 81, that's 171. Okay, so wow, I hope that these are not, is this thing repeating itself? Is this thing, if these are actual applications for subpoena, oh my gosh, if these are actual applications for subpoena, and now we're seeing 5, 6, 10 of them in the week before the trial, right? Starting here on May 26, 2026, that's one subpoena applied for by the defense. 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16. If this guy put in 16 subpoenas the week before the trial, there's no way that he had time to fully digest that information. We don't even know if he ever received the information. Now, here's the thing, and you guys know because I've played the videos on my channel. Everybody sees something different when they look at this information. When you look at the pictures, everybody sees something different. When you look at the video, everybody sees something different. You cannot examine, what was my number right there? 30 something, 40, whatever it was, in the week before trial started. He didn't stand a chance. All right, so a week later, the last subpoena was granted and then it had to be served, was May 26th. Then there was Labor Day weekend, right? Remember, Labor Day weekend would have happened in there. And then on, not Labor Day, Memorial Day, sorry, Memorial Day weekend. And then on the 1st, we start the trial. On the 1st, the jury is seated. The jury questionnaires are distributed. The jury is chosen on the same day. The jury panel list received, meaning from the parties. The jury panel seated, voir dire completed. The jury is selected. So in 48 hours, they seated the jury pool, seated the jury panel, and then actually seated the jury. The defendant officially pleads not guilty. That's just a formality. He had already pleaded not guilty, but this is just a formality of him pleading not guilty again. The jury is sworn in and opening statements begin. Now, here's the thing. It's not uncommon for the trial to start right after the jury is actually seated. But if you guys have watched my other videos, you've heard me talk about when you rush a trial, the party with the least resources is the party that's at a disadvantage, right? So as jurors are being picked, you're also editing your opening statement because there's a part of your opening statement that is speaking directly to every single juror, right? When you open your case, you're speaking to specific jurors. When you're closing your case, you're speaking to specific jurors, right? Because different jurors need to hear the same thing differently. They need different analogies. They need different examples, right? Some need a logical approach. Some need an emotional approach. If you don't have resources and you go right from swearing in the jury to doing your opening statements, you don't have time to edit your opening statements. The other side that has multiple people on their team, they can insert or reword different parts of your opening statement for you to speak to what they know about this jury, right? So if you've seen my other videos, you know that I say that rushing this trial very much disadvantages the small person, okay? All right, so on the same day, opening statements begin and opening statements close. State's witness testimony has begun. This thing is moving fast, you guys. All right. So here's the trial court certification of the defendant's right to appeal. Happens in the middle of the trial. And here is a stipulation of evidence. Now, what a stipulation of evidence is, and this is during the trial, right? So up here, we're doing state's witness testimony, and we're doing a stipulation of evidence. What a stipulation of evidence is that it avoids the party that wants to introduce the evidence from having to go through the legal procedure and maneuvers to get that evidence accepted. And when the other party stipulates to it, they're agreeing that it's legit, that it's valid, and that they have no issue with it. They don't want to cross-examine it. They don't want to authenticate it, etc. Right? It's just sort of it's like a gentleman's agreement. Like, can we just agree that this is what we say it is? And the other side will say, yes, I agree. That's a stipulation of evidence. Now, you can make a big mistake stipulating to evidence if that evidence turns out not to be what you think it is, or if the jury finds that it means something different, okay? But there is a stipulation of evidence here, which means that the parties agreed on some piece of evidence, we don't know what. Which, let me just say, people keep asking, where's the murder weapon? They could have agreed that the picture would suffice. I don't know, because it doesn't say what evidence was stipulated to, but that could be one explanation for why there was no murder weapon, right? A lot of people are asking this question. I don't know. I'm not saying that that's what it was, but they could have agreed to stipulate to anything, right? Okay, let's keep going. So now we are still in the part of the docket about, this is happening actually during the trial, okay? Trial is actually happening. The state's witness testimony continued. So let me tell you who would be putting this in, right? So this is going to be the court clerk or the judge's assistant, who basically is just updating the docket of what happened on that day. It wasn't because of a filing. It wasn't because anything was submitted to the court. It was just creating the permanent record so that on this date, you know that court was just still going on, right? It's just to create a fuller record for people who go back, so that it doesn't jump from opening statements to closing statements, right? You can see, it also tells you that nothing special happened on that day, right? It just telling you that it was regular court. It was the state's primary case. So on the 6th, it was also the primary case. On the 6th, also the state rested its case. Now, the defense asks the court for a directed verdict, and the court has denied the request. Let me tell you what that means. And then defense did what? And then it says defense witness testimony has begun. But let me talk to you about this directed verdict. Basically, what the defense did was, by asking for a directed verdict, they're asking the court outside of the jury, now that the state has rested and the defense has examined the entire put on of their case, the defense asks for a directed verdict, meaning, judge, we want you to find for the defense. We don't need to hear from the jury. What that means is, we are asking the judge, we are asking you to find that the state, who bears the burden of proof, that the state has not made out their case. They have not made out their burden of proof. Now, this is somewhat formulaic. Sometimes it's more warranted than others. Now, I'd heard a rumor somewhere, and it could have been one of the court watchers, I can't remember, that someone said that the reason the defense may have rested so early is because they really believed that the prosecution had not made out their case. That is a big mistake, to rest believing that the other side just hasn't made out their case, right? So if the state has not made out its case, or made out a strong likelihood of its case, that's when the defense asks for a directed verdict. The judge, the court here, the court is the judge, the court has denied that request, meaning the court believes that there's enough information that was put forward by the state to give the jury something to talk about, right? The defense is basically saying there's no case, there's nothing for the jury to even decide on. By denying that request, the court is saying, no, I believe there is something here for the jury to chew on. Okay? Now, given how fast the jury ended up chewing on it and deciding for the prosecution, that just goes to show you how off base, perhaps, this request for a directed verdict actually was. All right. So then the next thing it says here that gets cut off, it says the defense, I'll read it again, the defense witness testimony begins, right? So when your request for a directed verdict is denied, and it is denied instantly, right? He says, Your Honor, I'm making a motion for a directed verdict. The judge says denied. Immediately, then the defense calls its witness. All right. So then on the 8th, the defense witness testimony continued, and then also on the 8th, the defense rests its case, right? This is when everybody thought that Karmelo was going to testify, and he didn't. He didn't. Okay, so court ended on that date, and then the next day on June 9th, this is crazy. This is crazy. On the next day on June 9th, the charge is read aloud to the jury, meaning that the judge reads the trial aloud to the jury, and then also sends them back there with a paper copy of it, so that while they're deliberating, they can review it. Now, the charge, unless something very bizarre happened here, the charge is usually agreed upon and argued by the state and the defense. They agree on what the wording should be, and if they believe that the wording, as the judge will read it, is not likely to be helpful, to be instructive, or in some way disadvantages their client, they'll literally quibble about words that are included, right? They also will argue about which actual charges should go back to the jury, okay? So after this is done, the closing arguments begin, according to the docket. And then it says that closing arguments ended on the same day and jurors were sent to deliberate. The jury comes back with a verdict 3 hours later that he's guilty of murder. Then on the same day, on the same day, the punishment phase of the trial has begun. The state rests its case in punishment. Defense witness testimony has begun. This was probably the mother who gave her impact statement. All of this on the on the same day. My God. So, wow. The jury reads the charge. Both sides do their closing arguments. The jury is sent to deliberate. The jury comes back with a verdict. He's guilty of murder. The punishment phase has begun. The state may or may not have said anything. Then the state rests its case in punishment. So let me explain this case in punishment. The primary case that the prosecutor puts on is the case in chief. Once that is resolved, which it has been because 10 minutes before was a guilty of murder, now you go into the case in punishment. Usually, a lot of people couldn't believe that this all happened in one day. Usually, there is a time period between the verdict and the sentencing. And what happens in that time period, it can be months, it can be days, it can be weeks. In this case, it was minutes. What happens is the prosecution creates a pre-sentencing report, right? It'll be called like a PSR. It's called different things in different jurisdictions, but basically what it is any experts that need to be consulted, the case law is consulted, right? And the state is going to make its suggestion. And then the defense will also write its report, rely on its case law. It will write something positive about the person. It will pull in witness, character witness statements, impact statements, all of this stuff. Both sides will have statements from people that knew the victim, people that knew the defendant. And then they set a date for the sentencing, right? So none of this happened. This all happened within, minutes. And then the mother gives her statement. Karmelo's mother gives the statement. The defense witness testimony concludes and the defense rests. Wow. All right. So now the judge, right? So again, this is a general docket entry, which means that it's just put in by the court clerk to make sure that all of the key portions of the trial are captured in the record. Because remember, this is the record that's going to go up to the appeal court, to the appellate court. Oops. This is the record that's going to go up to the appellate court. You guys, I'm going to get to, oh, Kwaku, thank you for the super chat. I'm going to get to the comments in a minute. We're almost done with this. And before we go to the appellate docket, I'll go through these chats and answer anything related to these in case I need to go back to them. Okay. All right. Okay. So now the punishment jury charge is read aloud to the jury. What that means is that, now that they're in the punishment stage, okay? And remember, this is the case in punishment now. Before we saw the case in chief, now that a verdict has come out, we're in the case in punishment, okay? So the jury charge is read aloud to the jury. This means that the judge is going to read something to them, telling them, I'm sending, basically something like this. I'm sending you back there to determine, the sentence attached to the verdict that you guys just delivered. Remember, Karmelo Anthony chose to be sentenced by the jury instead of by the judge. Could be because they didn't like what they saw in that judge, and he may have given them given Karmelo the maximum. So anyway, so now the judge reads this language. He reads it word for word. He reads it off of a piece of paper, and closing arguments begin. Again, this is a busy day. This is a busy day. All right. So then the closing statements, the two sides, they finish talking and the jury is sent to deliberate. The jury comes back. We know that it was 3 hours later. They come out with the verdict, 30 years of confinement in the Texas Department of Criminal Justice. Let's keep reading. Court sentences the defendant. Okay, so this is the court now affirming the jury's decision. And Karmelo was given 12 days of time served. So it will be 34 years, 353 days, because he got 12 days of time credit for time served. All right. So here's the plea. I don't know what plea they're talking about in a disposition. I don't think this is a plea from Karmelo. Okay, and then bam, he's my goodness. The Texas Department of Criminal Justice prison. This is a busy day for Karmelo. The jury charge, punishment instruction. I think they're just updating the docket, or it's possible that somebody came and adjusted the document a little, because this is pretty much saying the same thing. Jury instructions, punishment, jury instruction. Okay, I think this is what I think right here. I think these things may have been added just to make sure that the record was clear for the appeal that these things did occur. Because we already saw that the jury instructions were read earlier in the day. I'm going to go back one page and show you those. The jury charge at the chief level, the case in chief level, the jury charge was here. And then going back to the page we just came from, the jury charge was read here. So I think this was just put here to make sure that the record reflected. It may have been put in by a different person, or maybe these were put in by one clerk and these were put in by another clerk. That I don't know. But this appears to be a duplicate. I don't think it happened twice. The bond is discharged. And basically what that means is whatever bail money had been put up for Karmelo was released, because he is now going into custody. The bill of cost, we don't know what those would have been. Let's keep going. All right. Okay, so these I think were just jury separation agreement, juror questions and answers. I think these things were just, again, I think these things were just updated to the record to complete the record. I don't think they're actually chronological, right? So if we go back one page, these things here, I don't think they happened chronologically. I think they were just put in to complete the record and to show forever that those things did occur. Same thing here. Okay. All right. So on the same day, I'm sorry, the next day, right? So on June 10th, one day after Karmelo was found guilty and sent to jail. A notice of appeal comes in. It does not tell who filed it. The defendant's note of appeal and pauper oath appointment of attorney on appeal. So what he's saying here is that he plans to file an appeal. Again, this is not the appeal. He plans to file the appeal. And, oh, by the way, I am indigent. We have to get to the bottom of what happened with that Give, Send, Go money, because there's something else that happened, and I'll get to that in a minute, that makes me think that Mike Howard did not get paid. But anyway, yeah, so the defendant files notice, and I don't know who would have filed this. It may have been Mike Howard. There was a court-appointed public defender, a court-appointed attorney, or a public defender that the court appointed. So maybe he quickly put in this notice of appeal and the pauper oath, right? This is the indigent. I'm indigent. I need an appeals attorney appointed to me. Okay. Okay. An email to the court reporter and the DA appeals. This is notice of appeal with the COA. I'm not sure what that is. Not the copy of the appeal. I'm not sure what this is, but we're going to see this guy, Donnie Perales, in a minute. He's in the appellate record. Oh, notice of appeal with maybe the cost of appeal. I'm not sure what this means in Texas. That's notice of appeal. An email to the court reporter, the CCSO, and the DA appeals. All right. Now here's the indigent packet, attorney appointment. Maybe this Danny Perales. He, I think, was the court appointed attorney originally, and apparently he's very good. Someone, if Jess Tiss is in here, she looked this guy up, and he's a very highly rated Texas attorney. Okay, non-party correspondence. Okay, supplemental notice of media attendance and request for post-trial exhibits. This probably was a request of some sort, either from the media or from some person in the public. All right, appeals filed, NOA with the COA, email to these people. Okay, appeals postcard. Oh, the Court of Appeal, sorry. Okay, let me back up. Court of Appeal. I couldn't figure out what that COA was. Filed the notice of appeal with the Court of Appeal, and then also emailed that notice to the court reporter, the CCSO, and the DA appeals. Got it. This guy appears to be filing, maybe he's accepting the position, or he's being provided with the packet as the potential appointed attorney, non-party. This is something that would have come from the public, perhaps the media. It's a request. The appeal filed with the court. Okay, this is a duplicate. Oh, amended appeal schedule. Okay, they may have scheduled something and now they're making an amendment to that. And then the appeals postcard. And this is what the Court of Appeals did. Now we're going to go right to that. We're going to go to that in a minute. The Court of Appeals is acknowledging the case. They've got the case now. All right. So that was a lot. We went through a lot there. Let me go to the comments before we get into the appellate paperwork, the appellate docket. Now, let me say this. If you just got here, first of all, welcome. Welcome. And so now what I'm going to do is I'm going to go into the chat and the comments, and I'm going to respond to them and answer them with any questions related to these documents before we move into the appellate document. If you just got here, basically what I've done is I'm trying to look through the court docket, all of the filings, all of the notes from the court clerk who was updating these things in real time, to see what Mike Howard did or did not do. We saw that the first batch of defense exhibits were put in by the second attorney, who was Derek Walpole. He put in, I think, 7, and we saw that one of them was not accepted. And then we saw it looks like he put in another batch of 4, and one of those was not accepted. And then Mike Howard comes in. And right after Mike Howard comes in, the state puts in a lot of requests for subpoenas. And as you know, a subpoena is just a request for testimony. It's a demand to either appear or to turn over something, evidence, documents, recordings, footage, anything like that. The state comes in and they pound out like 40 applications for subpoena. It appears that they were all approved. At that point, they were about 3, 4, 5 times the number of requests made to the court than the defense made. And then we saw the prosecutor make a request to have an expert witness allowed. It was granted. We never saw the defense make any application for an expert witness. Some people were going back and forth wondering if the defense expert witnesses were excluded. Were they denied by the court? I don't see any of that. We went through this record line by line. We clearly see that the state made a request, but the defense did not make any requests for expert witnesses. So then 1 week before the trial, for some inexplicable reason, the defense puts in 16 applications for a subpoena. They all appear to have been granted, but now those subpoenas have to be served on somebody. And then that person needs time to either appear in court to gather the documents or gather the information. This is a really bad look. We don't know what any of these subpoenas were for because the docket does not show that. The appellate team will most likely get the full trial records, which will actually have the motions, right? It will have the exact copies of the subpoenas requested, but it's not a good look. You cannot manage 16 new pieces of evidence, 16 new witnesses, 16 new documents, 16 new pieces of footage, or whatever the combination of those things were. You cannot manage that in 5 days, 6 days before trial, especially when you put Memorial Day weekend in the middle of that. From the time the defense made those subpoena requests on May 26th, actually, I'm hoping, maybe Memorial Day, you guys tell me in the chat, was Memorial Day this year before the 26th, or was it after the 26th? It falls on a different, weekend in May every year. Let me know. Either way, if he put him in the Friday before Memorial Day, then the following week was a short week. If he put him in after Labor Day, he was already in that short week. So either way, it's just absurd. It is just absurd. Okay, so that's just to bring you guys all up to date. And then fast forward, the trial started, the jury, all that stuff started on the 1st. By the 9th, he was already in jail. Okay. All right. And then also on the 9th, the verdict, the sentencing, the arguments from the parties. Okay, so that's where we are now. So let me go here. All right. Let me see what these. Can I move this? All right. When does this start? Hello, Tracy Perkins. It was starting right then. It took me a minute to get the thing pulled up. All right. I lean towards the theory that Howard set Karmelo up to win the appeal because he knew he was powerless to save him from being railroaded. All right. I think who's that? Oh, you definitely saw my video about the defense. All right, let me jump into Kwaku, thank you for the super chat. You're not even asking anything. I appreciate you so much. I appreciate you. All right. I'm just scanning to see. The website was let me see. It was the website was the Collin County court website. I think that's what you're asking. The Collin County court website. You're hoping he did something, weren't we all? But I mean, I laid it out for you guys line by line. You saw what he did. You saw when he did it. You saw when he did not do it. Do I believe that it is due to the fact that they would have hurt the defense? What would have hurt the defense, Mariah? I'm assuming you were talking about whatever I was talking about at that moment, but I just don't remember. All right. Is S.A. Tyrell? Thank you for this. Get ready with me for work. Yeah, so I am that somebody. So like I said, that, and it's not totally um it's not totally unheard of that people go in and they backdate the docket, especially if it's not for important things. Like once you know that there's going to be an appellate procedure, it's not uncommon to go back and insert entries into the record just to make it more complete. You can't, if you insert something that is suspicious or something that was significant enough that it should never have not been included, then you raise some issues. But sometimes people just go back and they clarify things, they expand things. So unless there was some kind of malfeasance there, right, unless we know they were doing something wrong or trying to hide something or cover something up, it's not totally uncommon. All right. Tammy, wow. Remember I told you to reach out to me? I don't know about that. Is this Fotina? Fotina? Let me know if I'm, where'd it go? Where'd you go? Okay. I thought I saw Fotina in here somewhere. Oh, you're responding to Fotina. Okay. I don't know about that. He's one of them. I don't know what you're talking about, but when you say he's one of them, I assume you're talking about Mike Howard. A lot of people think that Mike Howard is one of the guys, and that he really was not on Karmelo's team. Now, I'm going to say this again. I am not sure that Mike Howard got paid, you guys. I need to see proof that Mike Howard got paid. Because if I'm not mistaken, Karmelo's money still was not released by Give Send Go, right? So it's possible, and this is very possible that Mike Howard jumped in thinking that there was a big pot of money, and that money never materialized because Karmelo was qualified as indigent this entire time. All right. So someone said, hi, everyone. Is he not getting a retrial? We're going to get into that in a minute. I'm going to show you. An appeal is not a retrial. That was purposely done. Okay. All right, we're going to go, you guys, we're going to get into the appellate document in a minute. I'm going to walk you through it line by line. And for that, we actually have documents. We have PDFs that we're going to open. If you haven't already liked, commented, subscribed, super chatted, feel free to go ahead and do that now. Especially subscribe, because I want to hear what everybody thinks, because we're about to go, we're going to actually read the actual documents. I'm going to tell you what it means. I'm going to tell you what can be gleaned from it. If you just got here, the most incredible thing about what we've seen is, first of all, in the beginning, there were 3 attorneys. Mike Howard is the 3rd of the 3 attorneys. Also, we can clearly see that the state requested an expert witness, and it was granted. The defense did not request any expert witnesses, and therefore none were granted or rejected. There was no attempt, from what we can see here, there was no attempt to enter an expert witness. And also the other massive thing that we saw, if you just got here, was that the defense counsel, literally within days of the trial starting, less than a week of the trial starting, they applied for and got approved 16 requests for subpoena. I'm sorry, applications for subpoena, which means that they were asking the court to sign off on these subpoenas so that they could deliver them to somebody, someone who would testify, someone who would turn over a document, with basically 4 work days between these subpoenas being approved and the trial starting. He puts in 16 requests. There's no way for the defense to process 16 requests. But we don't know why. We don't know why he waited, right? There could be a reason for it. I'll just say that. There could be a reason why he waited. I want to see, someone said everybody should be in prison for tampering with the evidence. Slim chance that this will be overturned. Who holds court on a Saturday? Let me speak to that, because some people may not have heard that. If you heard the if you heard the interview with Judge Roach that he did, where he claims that he does not know the Metcalf family at all. He says it out of his own mouth, and he'd be a damn fool to say that out of his own mouth and then something actually turn up. He said that the pictures were AI. If that is a lie, it will come out, and he would be a doggone fool for that. But anyway, who holds court on a Saturday? So what he said in that interview was that there were so many logistics that had to happen, and given the high profile nature of the case, they needed law enforcement, local law enforcement, state law enforcement. They had to reschedule a number of courtrooms. You know, they had to coordinate with the media. They had to coordinate with the people who had petitioned and applied to get seats in there. They had to do a lot of things, right? They probably, if they had streets and entrances blocked off, right, that's probably the city works department, right, the maintenance department pulling out dividers and all kinds of cones and all kinds of stuff. So basically what he said was that because of how high profile it was and how disruptive it was to the normal functioning of the court to have such a high profile case, he wanted to move it along as fast as possible. That's why he decided to have that one day on Saturday. Because he said all of the other, I'll tell you something else he said, and y'all tell me if you caught this. All of the other judges had to host their courtrooms on Zoom that day so that they wouldn't have any other people in the building. Did you guys catch him say, and you know, they're all elected judges? Let me know in the comments if you guys heard him say he himself is an elected judge, right? And the thing about elected judges, there's a big difference between elected judges and appointed judges. Elected judges are always playing to the people because they want to get reelected, right? So they will feel election pressure when they're making decisions. Now, he was about to retire, or maybe he was forced to retire. I don't know. People are saying different things. Anyway, all right, we're going to get into the appellate right now. All right. Thank you for the super chat, E.L. Summer. Our future lawyer, E.L. Summers, is going, he's considering a career in law, and I'm fully in support of it. Thank you for the super chat. He says, this might be more than Mike Howard got paid. This might be more than Mike Howard got paid. No expert witnesses. This definitely looked like a free defense. They called his mom as a witness. Absolutely. That's what I'm saying. I have reason to believe that he did not get paid. All right, let me just scroll through these quickly. Because there's a lot here and I want to move on. The new legal team is pro bono. Yep. But the appellate attorney that was appointed to him, according to Jess Tiss, and I think she's in here now, she did some research on this guy, and he's a very highly rated Texas attorney too. Okay, so let me get into the appellate. I don't have time to get to all of these. Thank you for those of you that gave me a super chat. I appreciate you. All right, so all right, so now all right, so this is, let me pull up the case. Let me see if this is it. All right, so this is the appellate court, right? And right here we see the appellate brief. No briefs have been filed, but all of these dockets here have been filed. All of these dockets here have been filed. I'm just scrolling down to see if there's anything. Punishment 35 years, Texas Department of Criminal Justice. We already saw that, Colin. All right, so let me draw your, are you guys with me? Let me draw your attention here. Sorry, you guys, I was on this page and did not share it with you guys. All right, so this is his case in the Fourth Court of Appeals. I'm sorry, the Fifth Court of Appeals. And we're going to get into, because here are all the, we have actual PDFs of these things. Only, let me see. No. Only one of them is really significant, but I'm going to tell you everything that you can get from that. So here we have the parties, right? The state of Texas, this is the criminal. And you guys may have heard in my other video, I said that in cases like this, the prosecuting attorney has the entire strength and weight of the entire state of Texas to bring to bear on this prosecution. The defendant only has the defending attorney and whoever else in their firm can be deployed onto this case, right? Sometimes that's one other person. Sometimes it's just a paralegal. Sometimes it's just a secretary if a defense counsel does his own paralegal work, right? So the fact that he's now coming in here with a bunch of heavy hitters is directly to counter the fact that they're going up against the state of Texas. They have unlimited legal resources to bring to bear on this case if they wanted to. Now, this is mathematics, right? This is calculus that they have to do. But if they wanted to put 30 attorneys, junior attorneys, senior attorneys, they could put a bunch of paralegals. They could put as many resources on this case as they want to. But now this guy has a he's got a powerhouse team. All right, so let's look at this. This is the complete appellate record. And let's go back. This one is in reverse order. Can we change the date? Oh, let's see if we can reverse this. Yeah, we reversed it. Okay, so now up here is the top. So on the 9th, this is the judgment signed by the trial court, right? So this is the last thing that the judge does before turning the person over to the Texas Department of Criminal Justice. All right. Additional copies of documents received after the initial filing. These are out of order. It should first say notice of appeal filed in the trial court. So whoever filed this, whether it was Mike Howard, it was pretty much filed within 1 day, which is great. It's a simple document, right? It's just kind of notifying the court of the court number, etc. And then here is a letter issued by the court. If I click this, let me see what happens. Do y'all see that? Okay. So what this is that you're looking at here, this is from the appellate court asking the court reporter in the trial court for all of the documents, everything related to this trial that the court reporter has. And it says, it looks like TAMES is the electronic system, right? So the court is asking, right, the court requests the court reporter to complete and file this form within 7 days. Basically, what the appellate court is telling the trial court, the stenographer or the court reporter, whatever you have, get it processed and uploaded to TAMES, our electronic system, within 7 days. And then, if you go down a little bit, this is what the court reporter would fill out. Was the proceeding recorded by a court reporter? Yes or no. They'd click yes. Are you the only court reporter? Now, you may have seen in my other videos, I have said that sometimes, occasionally, especially in high ticket cases, you will see the defense provide their own court reporter. And the reason for that is to catch discrepancies, because as hard as these ladies work, and sometimes they're men, they're often ladies, as hard as these stenographers work, errors do happen. And there have been cases where the mistake was actually material. The mistake was actually a material matter, meaning a word got left out, or a no or a not got left out, or a before and an after got switched, and it changes the meaning of the testimony. It changes the meaning of the facts, okay? And then it says, has the appellant requested... Okay, so question number 3, the appellate court is asking the court reporter whether or not the defendant has asked for, well, let me not say the defendant, whether or not the appellant has asked, right? The appellant is the person who's bringing forth the appeal. Usually the defendant, there may be a case where it's the prosecution, okay? They're wanting to know, has the appellant also requested these records, or has the court itself requested these records? And then they want to know who is paying for them. And That's it. Okay, now when it says requesting permission to file physical copies, what the appellate court was asking was for them to upload these files to the electronic system. And it says here, if you need to file physical copies, explain what you've already tried and why it can't work. Okay, so this is a simple document. And now we're back to the main thing. Okay, so the docketing statement due. The docketing statement. The docketing statement is an important document that starts the appellate process, and it basically gives to the appellate court all of the information that it needs to start its file up. Now, I think these things would have been out of order because it doesn't matter. They all happened on the same day. This is one day after the verdict. These things may not actually be in order. I think they should have been in a slightly different order, but it doesn't matter, right? The first thing would have been the filing of the notice of appeal in the trial court, and then in the appellate court, and then the docketing statement, and then the letter issue, but it doesn't really matter. All right, so this is just a note. This is just a note from the Court of Appeals to the appellant, to Karmelo Anthony, noting that the docketing statement has not been filed, that they have notice of the appeal, but they don't have the docketing statement, which we're about to get to in a minute. Sorry, this is the letter. I have to remember to share it. This is the letter from the Court of Appeals, noting that while they have received the notice, the notice of appeals, they have not received the docketing statement, and we're going to get to that. Okay, so then the next thing we see is that the notice of appeal is filed in, again, this would have happened first, is filed in the appeals court. It's already been filed in the trial court, and now it's being filed in the appeals court. Let's see what that document, this is a standard, this is kind of a printout of a record. Oops. Hold on. Okay. Again, this is from the Court of Appeals. This is now just saying that the appellate court has filed it. Basically, all you see here is you see a bunch of different copies of this. The only difference will be the name of the person under the line, right? Like here is Michael Gould, who is the Collin County District Clerk, but this is just repeating itself. Janet L. Duggar, she's the court reporter. She is the one who would have been the court reporter in the trial court. And then this one here, this is the Amy S. Murphy. She's in the DA's office. She's the chief of the appellate division. So that's all that this is really showing us. But let's look at the last thing. All right, so the last thing that's really interesting is this document here, and it has a lot of information on it. So I'm going to walk you through this document. This is the docketing statement. This is filed immediately after the notice of appeal is filed with the trial court, and then the notice of appeal is filed with the appellate court, and then this comes next. Okay, and this is just a bunch of information for basically getting the appeal started. Okay, so when this is submitted, it's a lot of information. It's a standard form. When this is submitted, the court clerk in the appellate court is just going to enter this information into the system. They probably have it so that it is scannable. Now I'm going to show you what you can learn from this. And it's just a lot of, it's really like a form, right, that they just fill out. But there's some stuff that you can gain here. Is the appellant, Karmelo, is he incarcerated? The answer is yes. Now, there's a strong probability that the very next thing that this defense team will do, if this appeal is accepted, what they will do is they will make a request to have him released pending the outcome of the appeal. And in that case, they would send Karmelo home with, or to wherever, with, an ankle monitor on or something like that, right? So look for that to come next. They're going to request for him to be released pending the outcome of this return. But right now, as of the filing, yes, he is incarcerated. The appellee is the state of Texas, right? So the appellant is the one filing it, the defendant, and the appellee is the one being filed upon. That's the no. Okay. All right. So there's something else, and I'm not sure why this is formatted like this. I think this vertical divider line, it could probably be moved over. I don't know why they wouldn't give equal weight to all four attorneys. But anyway, okay, so here is a list of the attorneys for the appellant, and then you'll see right here, lead attorney is checked for this guy, Russell Wilson. Now, there's something interesting that you can see here. You can see kind of the age of these attorneys, right? So Russell Wilson is the older guy with the salt and pepper afro. And his bar number starts with 00. That means this is an old school attorney, right? He's been barred since the mid 90s. And you can tell because his prefix is 00. And then within that, so the way Texas has done its bar numbers, and you can see how old and experienced these attorneys are or are not. We should look up and see what Mike Howard's bar number is. But anyway, the 00 was a prefix that was used many, many years ago. And in that numbering system, he was the almost 800,000th attorney licensed by the state of Texas. And then this other guy, he's been around the block for a while too, because maybe not as long as this one, but his number starts with 20. And then these young attorneys, they all start with I don't know what this is. The 24, right? So this is when the numbering system has reset. So you can look at these numbers and tell how long these attorneys have been in here. But this 00, they don't even use the 00 anymore. So this guy's been around the block a few times. And then these guys are younger. Okay, that just so you know. So anyway, so where are these attorneys from? Dallas, Fort Worth, Frisco, Austin, Dallas, and Dallas. Okay, so I want you to look here. Okay, so all appellate, remember I told you that there was an attorney appointed for the appeal. The guy's name was, I can't remember what I said it was. It started with a D. This woman appears to have been appointed before him. So he may have had two court-appointed public defenders before these come in to take over the case, right? Because they say that all of these attorneys are substituting in for the prior court-appointed counsel. All right. And her name is Laura Bracamonte. Okay, now here is the appellee's attorney. This is the state's lead attorney, Amy Murphy. She's the chief of the appellate division. Now, the appeal, unless they get a new trial, it doesn't involve courtroom work. It's written on the papers. It's a lot of writing, right? Appellate attorneys are writers for the most part. They're writers and researchers. They work upstairs in offices. They never see the public. But if he's granted a new trial, they will do a new trial. And she may or may not actually try the case. She may just be the lead attorney and her office will handle it. All right. His plea was a not guilty. Trial by jury, we already knew that. This says notice of appeal filed in the trial court on June 9th. In the docket, it was recorded on June 10th, which is not uncommon. Depending, it may have been filed the night of and not recorded until the morning or something like that. Is this appeal from a pretrial order? The answer is no. Pretrial order would mean that they're appealing based on something that happened before the trial even started. Now, this is interesting here, okay? Does the appeal involve the constitutionality or validity of a statute, rule, or ordinance? The answer is no. This would be if they're challenging the actual law itself, and they put no. So that's telling you that they're not going to say that there was some portion of the law that was not right. They're basically saying by that, no, we're going to do this based on what happened in the trial room. That I was going to say that day, but those like 2 or 3 days. Now let's look at this motion for a new trial. Yes, they want to start a new trial. So they want to scrap the whole thing and start over again. Now, this is, I mean, a lot of people request this, but you also have to have grounds for it. So they believe that they do have grounds, right? A motion for a new trial means that we want to go back to the drawing board. Now, here's the thing about that, right? I was actually happy, and someone wrote about this in the comments today. I was happy that they gave him, that they convicted him of the highest charge, because even if they had convicted him of a lower charge, they could have given him the same amount of time. But the lower charge is actually harder to appeal. And if you do appeal, or if you do get a new trial, you run the risk of getting a second trial and getting murder one. Because he already has murder one, there's no harm in asking for a new trial. So I was glad that he did not get the manslaughter. Because again, he could have gotten the same amount of time or something seriously close to it anyway, even with the manslaughter, and had a harder time appealing it, and would have possibly gotten a higher sentence. Okay. Motion and affidavit filed. Yes. Okay. So here we go. The appellant has previously been found, and this is where I am in the middle of this page. The appellant has previously been found indigent by the trial court. Substitute counsel appears, substitute counsel, plural, appear pro bono, and the indigency finding is requested to be maintained for the record without cost. Okay, so if you remember in the trial record, there was a line there that said there were 2 sets of fees that he was not charged. He was not charged the fee to be arrested. Can you imagine having to pay a fee to get you have to pay them to arrest you? And also he didn't have to apply. He didn't have to pay to apply for counsel, for indigent counsel. Okay. So substitute counsel appear pro bono, and the indigency finding is requested to be maintained. There's no reason to not maintain it. God forbid something happens and they have to come off of the case. The record and the finding is already there. He can move on. Now, another thing that they could have done, I think, unless Texas prohibits this, they could get the appointed counsel fee, which is nominal, but it would certainly help offset some of the costs. Right. But this particular group of heavy hitters, that would almost be beneath them. Right. But they could apply for the fee that would be paid to an appointed counsel. But again, this is a powerful team. Okay. The trial court clerk was a district court. We know that was Judge Roach from the 296th district. And was the clerk's record requested? Yes. So remember the document that we just looked at, the one that the clerk has to fill out. Oh no, that was the court reporter. Oh. Okay, so the clerk, well, this actually makes more sense. The clerk's record is the one that we were looking at, that where I was saying that those things look like they were updated after the fact. When the clerk got this request, they may have gone back and just filled it out before turning it over, right? And that's why we see those repeated entries that appear to say the same thing. When the record was requested, they went back, they cleaned it up, polished it up a little bit before turning it over, okay? And he did not have to pay because he was indigent, all right? And now this is the one for the court reporter, the stenographer, right? Was there a reporter's record? Yes. Was it requested? Yes. Now, remember the document that we just looked at that is to be filled out by the stenographer. One of the questions was, has the appellant requested the record? In this case, the court reporter would answer, yes, they have. And then when the next section, remember it said who paid for it? the court reporter and the party are both saying indigent, meaning that he would not pay it, meaning the state would absorb the cost of that. Okay, so, and here's Janet Duggar. We already saw her. Anything related, any other related matters? There are none known. Okay, and signature, electronic signature by the attorney. Okay, so this is what we have in the document. So what do we get out of this document? We get that they have requested a motion for a new trial, that they still want him to be treated as indigent, even though they're stepping in pro bono. This powerful team of 6 attorneys and their firms, right? The next thing, so that's what's on here. That's what we can garner from here. The next thing we're going to see, if this is accepted, we're going to see the actual appeal be filed. And then if the court agrees to hear the appeal or to work on the appeal, we're going to see a request that Karmelo be released pending the outcome of this appeal. So all right. Okay, so that is the court docket. Now you know everything that has happened. You know what it means. If there's anything that wasn't clear, anything we need to go back and look at, let me know. But I want you guys to see the stuff for yourselves, decide for yourselves. I told you the big things I noticed, the big error that Mike Howard did, if he really did file those subpoenas within 4 working days of the trial starting. That of everything that we've seen, that blows my mind. I told you guys they would put in a request for a new trial. Oh, they also asked the judge to recuse himself. Hold on. Let me get back to, where was that? Let me get back to that. In here, they are asking the judge to recuse himself. Let me see if I can find that for you guys. Did I talk about that? Oh boy, let me see. Hold on. Here we go. Let me share this. I skipped right over it. Sorry, you guys. If you see, all right, let's go here to related matters. Okay. This here says, list any pending or past related appeals before this or any other Texas appellate court. List them by court, by docket, and by style. The attorneys here are saying that we don't know of any other related matters pending in the appellate court. However, post-conviction motion for new trial and motion to recuse are pending in the trial court. Now, if you watched my video, what was that video called? Something about is Karmelo Anthony's attorney playing chess, not checkers? I talked about this, okay? I talked about how when you make a motion for a new trial, that motion goes directly to the judge who just heard the case. So the chances of that judge saying, hey, you know, you're right, I did blow it. Let me give you a new trial. They are not going to do that. So what they are doing here is they asked him for a motion for a new trial and a motion to recuse. Now, what they're basically saying is that we don't want you involved in this case anymore. So someone else should decide on this motion for a new trial instead of you reviewing yourself. And we definitely don't want you to be the one who rehears the case. If we do get this motion for a new trial, we don't want you to be the one hearing it. So they're saying that while we don't know of anything, any matters, while we don't know of any matters in the appellate court, just so you know, there's also a motion for a new trial and a motion to recuse in the trial court. So if they get the new trial, they will start from scratch. And remember, in that video, right, the chess or checkers video, I told you that if they get the new trial, because Karmelo did not testify in the original trial, the prosecution will not have his testimony to dissect word by word, line by line. They will be at a disadvantage in the new case if Karmelo does take the witness stand. So this is where Mike Howard may have been playing chess. He may have decided, I'm not going to put Karmelo on the stand and have him tell his whole story so they can break it apart and look for any holes and find contradictory evidence, etc. If he knew that they didn't stand a chance based on whatever that back and forth was at lunchtime on the last day, when he came out of that lunch break and rested, and for basically how the trial was going, maybe the fact that some of his subpoenas were not approved, right? He may, and I don't know, he may have decided very early on or even before the trial, certainly when he didn't get the jury that he thought was fair, he may have decided to not put Karmelo on the stand. If they get this new trial, I can almost guarantee you that Karmelo will take the stand and he will be prepped and he will be right. Also, those last minute subpoenas that he put in, if he decided before the trial that he wasn't going to actually try the trial because he didn't think he had the right judge, the right prosecutor, the right jurisdiction, he may have just thrown those subpoenas in at the last minute to preserve them. So we don't know. Mike Howard, this guy might be 2 steps ahead, but if they get this new trial, they start from scratch. But they will not have the benefit of having heard Karmelo. The defense will have the benefit of having heard all those students. So this could go either way, you guys. This to me is the hottest question. If they get this new trial, start from scratch, and then put Karmelo on the stand, the prosecutor will be scrambling. They will be scrambling to try to attack his thing. And this team is going to prepare Karmelo. Anyway, so I just wanted to pull this back to your attention. Is this the same 83565? Let me see. Is this the main court docket number? Yeah, it is. Okay. Oh, wait. 83,565. 83,5. Okay, so it's in the same docket. Okay, so this is where all the excitement is going to happen. If they get a new trial, can you imagine? This is going to be awesome. All right, so anyway, let me get to and the fact that they're asking the judge to recuse. That's not uncommon in a motion for a new trial, unless you think that the judge is actually helpful. If you think the judge is helpful and the jury just got it wrong, then you might not want the judge to recuse. You might want, because you may think the judge is going to agree with you, like that jury came out of left field. But here's the thing. If the judge really believed that the jury came out of left field, the judge could overrule the verdict, right? The minute that the verdict is read by the jury, the judge could have overruled it. And right, that doesn't happen very often, but it does happen. The judge will say, you guys don't know what you're talking about. You couldn't possibly have been looking at the evidence that was presented in this court and come to that conclusion. And then the judge will overrule it. One of the catch-all reason for, actually, I can show you this. I'm going to show you the grounds for a new trial. But let me just come here and look at bear with me, you guys. I'm trying. There are so many comments in here. Okay, I can't look at all of these. All right, you guys, thanks for turning out. I appreciate it. I'm going to go into now. Let me show you the Texas the Texas rules for a, hold on. Let me show you the Texas rules for granting a new trial. All right. Okay, so this is the Texas rules, and this is just a PDF. Can I zoom in any? Let me zoom in just a little bit. All right, new trials in criminal cases. So we want to go to grounds. This is the grounds for a new trial. And I'm going to show you, let me see if I can zoom in on this a little bit. Okay. All right. The defendant must be granted a new trial or a new trial on punishment, right? Remember I told you that the case in chief is its own little trial, and the result of that is the verdict. And then the sentencing phase is the second part, which is called the trial on punishment, right? So they're both technically, they're mini trials, right? The case in chief is when this is the he did it, he didn't do it. And then the sentencing part, it resembles its own little trial because it has opening statements, closing statements, evidence, exhibits, arguments, and then a trier of fact, the jury in this case, often the judge, will actually attach a punishment to it, right? Okay, so a defendant must be granted a new trial or a new trial on punishment for any of the following reasons. We don't know which one they requested. I'm assuming it was a full new trial. Okay, because they don't want to, if they only file for a new trial on punishment, that means they're agreeing with the underlying trial. They're agreeing with the underlying verdict. They just they don't like the sentence. They're trying to attack the whole thing. All right. So, a new trial must be granted when the defendant has been unlawfully tried in absentia or has been denied counsel. That does not apply here unless denied counsel can be read to mean denied adequate counsel, right? This is the ineffective assistance of counsel. Why does this thing keep popping up? Oh my God. Okay. Or when the court has misdirected the jury about the law or committed some other material error. This is legal error, right? This is what we call legal error. I don't know. They may make this out, right? We'd have to see the transcript. We'd have to see all of the objections, etc., to know which one. And they can come in under any of these or multiple of these. This is when the verdict has been decided by lot or any manner other than a fair expression of the jurors' opinions, right? So that's like if the jury went back there and they said, listen, we all want to get out to the football game. It's getting hot in here. The air conditioning is out. Let's just pull straws. Let's just do heads or tails. Heads, he's guilty, right? You never hear of this anymore, but there have been some cases where random things like this have happened, arm wrestling matches and all kinds of stuff, right? Because when they get tired, they're like, instead of being deadlocked, let's just get this resolved. And then they arm wrestle or something like that. When a juror has been bribed to convict or has been guilty of any other corrupt conduct. Now, if the Metcalfs weighed in on the jury, a lot of people think that they intimidated the students. I don't know. We'll see that something like this would come out. God forbid there were any payments, or a bribe could take a lot of forms. It doesn't have to be cash money. It could be, we'll let you onto the team next year. It could be, you'll be a starter next season, right? It could be money, or it could, any other corrupt conduct. That's a pretty broad statement, right? Okay. When a material defense witness has been kept from court by force, threats, or fraud, or when evidence tending to establish the defendant's innocence has been intentionally destroyed or withheld, thus preventing its production at trial. So this is getting into a Brady violation. I am doing a video on this probably Tuesday about whether or not the prosecutor had any Brady violations. A lot of people think the prosecution did not turn over all of the footage. So we're going to talk about that. Now, basically, a Brady violation says that if the prosecution has any evidence or comes to have any evidence at whatever point they come to have evidence that is exculpatory to the defense, meaning it tends to show innocence or exonerates the defense, They have to turn it over whether or not they're asked. And if they have anything that impeaches one of their own witnesses, one of the state's own witnesses, they also have to turn that over without being asked. At any point in any time in the future that they come to know of it, they have to turn it over to the defense. Okay. But let me say this. This rule, which touches on Brady, says intentionally, that it was intentionally destroyed or withheld. The U.S. Supreme Court Brady rule says intentionally or accidentally destroyed or withheld. So this is narrower than the U.S. Supreme Court, which means that the U.S. Supreme Court would trump it. Because this says that the act of holding it back or destroying it has to be intentional. The Supreme Court said in U.S. v. Brady or Maryland v. Brady that the U.S. Supreme Court finally decided in U.S. v. Brady intentionally or accidentally. That's a big difference there. Okay. Or, right, the defendant must be granted a new trial when, after retiring to deliberate, the jury has received other evidence. They've talked to someone else about the case, or when a juror became so intoxicated that his or her vote was probably influenced as a result. Now, I know these sound crazy, right? Like a drunk juror, fumbling around, but these things really happen. These rules come from real cases, and they just get codified. Right? It's been a long week. We've listened to a lot of testimony. Whew, let's pop a bottle of whatever this is. Let me pop one of these pills just to relax so I can talk about this, right? These things have actually happened, okay? So received other evidence means that somehow they got a hold of some evidence that was not entered, or they did not hear it in the time of the proceeding. They heard it on the news. A buddy of theirs slipped a note, into their mailbox. Anything like that, right? The prosecution slipped them an envelope that was not admitted. Whatever it is. Okay? The defendant must receive a new trial when the jury has engaged in such misconduct that the defendant did not receive a fair or impartial trial. This is different from saying that the prosecutor or the judge did something. This is saying that the jury did something. The jury did something that was so wrong that it literally hampered the defendant's due process rights. And then the last one, and this is the one you can get a lot of stuff in under this one. This is sort of the catch-all. When the verdict is contrary to the law and the evidence, right? So this, you can capture a lot of stuff in here. This is when this verdict is so far removed from either what the law says or what the evidence says, then this person gets a new trial. Okay, so all right. Okay, so let me get to the chat. Oh my gosh, there's so many messages in here. All right, you guys, if you want me to read your question first or not to forget to mention it, then, whoa, what's going on here? Then send it with a super chat. Otherwise, I'm just going to scroll through. There's so many here. Oh boy. I'm just going to scroll through here. Go ahead and subscribe if you're not a subscriber, and comment so that I can know what you guys are wanting to know if I need to go back. Okay, Cycle Breakers Journal, great analysis. Thank you. Thank you for being here and being a subscriber. All right. I do see, whoa, this is a lot of, I appreciate you guys for coming in. I do see a super chat here. Thank you, Egyptian. Where did it go? Egyptian deity, 1862. Thank you. As a hoe for A, whenever I'm sent a flash drive and I can't make out what's going on, I don't consider it. As a hoe, I don't think that's what you mean. Homeowner for AT? Egyptian deity. What? There's too many. That's too many. As a, whenever I'm sent for a flash drive and I can't make out what's going on, I don't consider it. Egyptian deity. What's a hoe? H as a HO, homeowner. as a whole for AT or at. You know, so you guys, sometimes when I'm on these lives and you give me these abbreviations, I can't quite figure it out. My mind is literally busy. And then sometimes, like yesterday, somebody was asking me about a particular type of claim and used abbreviation. I couldn't figure out for the life of me what they were talking about. As soon as I got off the live, I was like, oh, negligent infliction of emotional distress. Egyptian deity, update your comment and your super chat. Thank you for the super chat, but I can't make it out what you're asking me. But I will say, if I understand, I just don't understand who you are, the HO for the HO for AT. But a lot of people, if they can't make out what's going on with something, they eliminate it, right? So I don't even know what you're talking about, but I can tell you that a lot of people, when people are confused, they ignore it. All right, I see you, Fatina. Oh boy. Okay, I think you guys are talking here to each other. All right, I don't know what Tabasco K9 Academy said or did, but you guys are giving them the business. Let me let me see if I can find the original chatter. Are y'all ganging up on this person? Do they deserve it or not? Okay. Okay. All right. Looks like you guys are handling whatever it is in the chat. No way. Alternative, what does it say? Alternative Insight Media. Mike Howard's bar number starts with a 24. Oh, he's a baby. He might have been in over his head. Yikes. So if that's the case, Russell Wilson, the lead attorney, if Mike Howard's bar number starts with 24, then Russell Wilson may have been practicing 20 years longer than him. Now, let me say this, and I've said this in other videos. I don't believe that a young attorney cannot win for you, because sometimes a young attorney is hungry AF. Sometimes they're inexperienced, so you have to balance the two. And sometimes they may be under-resourced or don't have the network. But sometimes young attorneys are very hungry, very, very hungry. And they don't have a totally full book of business, and they can give you the time. All right. Let's see. Egyptian deity, did you come back? Okay, so someone said, do these documents include the preserved objections? The answer is no. We need the transcript for that. And the transcripts have not. Let me just hide this person. The transcripts have not been released. The transcripts will show the objections and the rulings on those objections, etc. Okay. All right. I think I got love. Well, yeah, I got love forever out of here. Tabasco, you might be on your way out too if I see you. Oh, okay. Oh, here. Thank you. Thank you, Egyptian deity, the HO and the AT. I am a hearing officer for the appeals tribunal. Okay, let me go back up to your post now. Thank you. Thank you, Egyptian deity. My brain, when I'm trying to do all these screens and read these comments, my brain is maxed. So as a hearing officer for the appeals, do you say tribunal? I think that's what you said. Appeals tribunal. Whenever I'm sent a flash drive and I can't make out what's going on, I don't consider it. Okay, there you have it. There you have it. So I think if I think I understand what you're saying, Egyptian deity, and thank you for the super chat. Um, the burden is on whoever is submitting whatever they're submitting to make it super clear and super easy and take the legwork and the steps and all of that stuff out of it. If I think I'm understanding what you're saying, and I certainly know that anecdotally, I do know that what you're saying absolutely does happen. It is true. Not everybody is going to wrestle with your stuff to try to figure out what you're submitting or what the evidence is and things like that. Okay, so someone here said Paxton will never release the video. He's a Collin County crony as well. Family resides in said county. Listen, first of all, watch my video on Tuesday. I'm going to be talking about whether or not they released all the footage, what footage has been released, because there's 3 or 4 layers of footage that are out there circulating, and then we're going to talk about what will happen if it turns out that they did not release the footage. Now, there's a couple of levels where that footage could have not been released. Okay, the security office had the footage. They would have had to turn it over to the district, probably the legal department at the district. The legal department then would have had to take a second stab at it and decide how much to turn over, either voluntarily or by subpoena, to the prosecutor. Then the prosecutor would have taken a third cut at the footage and decided what they needed to enter into evidence. Then the fourth thing, which I think is the same as the third, but we'll find out, the fourth thing is the court would have had to decide what to release to the public. So the security makes a decision, an editorial decision. The district's legal department makes an editorial decision, and you better believe it's in conversation with the superintendent of the district. And then third, the lawyer will make a cut, the prosecutor will make an edit, and then possibly, we have no reason to believe this, but possibly the court then would itself decide what it wants to allow into evidence and also what it wants to release to the public on that page. So that evidence could have been chopped up and cut up in a bunch of different places. So people are saying the prosecutor withheld it. It's possible that the camera operator withheld it. The head of security edited it or took a couple slices out. The legal department for the district cut out a few minutes. The prosecutor edited it the way the prosecutor wanted, and then the court, right? So that footage has been cut up so many times and could have, and it's all editorial, right? Every time they make a cut, it's editorial. Do we think this is important? Do we think that this is material? Some people believe they don't have to turn over evidence unless it's material. And depending on how you word your request for the evidence, your subpoena for the evidence, it could only ask for material stuff, in which case the person turning it over gets to decide what is material. So we don't know. Paxton may not have all the information himself. So we're going to get into all of that on Tuesday. Who might have done it, why they might have done it, and what's going to happen if they do it. And whether Brady, the law that requires that all exculpatory evidence be turned over, whether or not that applies to the security department at the school. And what that's going to come down to is whether or not they are law enforcement, because the Brady responsibility, the Brady duty goes down to law enforcement working with the prosecutor. So if the security department at Frisco is actual Collin County law enforcement or local law enforcement, if that's who mans that security department, then the Brady requirements go all the way down to them, which is going to be a whole different beast, right? Because now we're saying that they too are liable to Karmelo if they don't turn that over. Okay, so anyway, we're going to get into all of that. That is its own thing. Okay. All right. He will be released just as expeditiously. I love that word, expeditiously. Just as expeditiously as they locked him up. Oh, okay. E.L. Summers, thank you for the super chat again. I'm not 100% sure that Mike even polled the jury. Now, that's a really good point, because we might have seen that in the clerk's docket, that that is the kind of thing that if it did happen, it should have gone into the docket. Now, they may have a, and I don't know because we weren't in there, but the judge may have said something like, so say you one, so say you all. And if they all said yes, then that may count as polling the jury. The reason you might poll the jury is if you think that something shady has happened, or that someone has been not abused or manhandled, but heavy-handed, that one of the weaker juries may have been what's the word I'm looking for? Not heavy-handed, but what's the verb? May have been kind of pressured into saying guilty. This gives them one more chance in a public space to voice their objection, right? They may have, if they felt threatened in any way, or if they felt like they couldn't, the pressure was too great inside the jury room, by surveying them at outside of the jury room, it gives them a one last chance to say, no, I did not agree with this. Now, there was a case. Anybody remember that case of the guy who got convicted, and then when they pulled the jury out, like a couple of the jurors were like, no, we think he's not guilty. Did anybody remember that case? And then he had to go back in. I think he ultimately had another trial and got convicted. Okay. Thanks for the question, E.L. Summers, and the super chat. Counsel Gray, thank you, ma'am, for breaking down the legal process, terms, and procedures in this case. You've been a great help. We all have great concern for Karmelo's life and future. Thank you. Absolutely. My thing is, and I'll say this over and over and over again, right? At the end of the day, none of us were there. The only thing that people want is to believe that he got a fair and transparent trial. If he got a fair and transparent trial and he still came out guilty, okay, it happens. People do things. But this charade, people can't live with this. It's not that everybody thinks that people think he got railroaded. It's not that everyone thinks that he didn't do it. He didn't, but the way it's looking right now, it looks like a cover up. It looks like he got railroaded. It looks like a lot of things, right? Okay. So thank you for the comment. Okay. So if you guys want me to show you where you can get this footage from and look at it yourselves? This footage, you guys, is not hard to find. Let me see here. This footage is not hard to find. It's on the court's website. I'm going to show you this right now. This is the court's website. For those people keep asking where to find this evidence, it's on the same exact website. If you scroll down, there are the links to the evidence. And these 4 video groups, they contain 10 individual videos. There's, I don't know, maybe 80 photos, and then I think there's 2. Let me see. Oh, no, I didn't mean to do that. Oh, they didn't open anyway. Okay, they went to my computer instead. Yeah, so this is the court's website. Collin County Detailed News. I don't know, something like that. All right, y'all got that? Oops. Did y'all get that? Okay, so for those of you who weren't here, I'm just going to back it up a little bit. I think I've answered all the questions that were asked to me. Looks like you guys are just going back and forth with each other, which I appreciate. If you are just getting here, basically what I did is I walked through the trial court docket, and the docket, just in case you don't know what the docket is the record of everything that happens in a case. Every filing, every order, every motion, it's supposed to, right? Dockets vary in terms of completeness and quality. This docket, I would rate it mid. But it basically, from the day the defendant is arrested through the whole appellate process, we started on the day that he got arrested, which was April 2nd of 2025. Every interaction where he got arrested, the very first appearance of attorneys, what we saw was that 3 different attorneys entered. I can show you who these attorneys were. Well, okay, that's a whole different slideshow. And then we saw the second attorney, who I think was called Derek Walpole. If you watched my video about why Karmelo's team keeps changing, I talked about the strategy of why they moved through all those representatives early, starting with that guy, Dominique, whatever his name was, the spokesperson, that guy, starting with him, who was a very strategic choice at first, right? I'm not going to say, for whatever he turned out to be, he was a good choice at first. And then, it kind of went left from there. But I walked through the entire docket, everything that happened. One of the things that we saw was that Mike Howard was actually the third attorney. He was the second attorney to file. He filed a couple of early requests for subpoenas, and we don't know if those were requests for testimony, requests for documents, requests for footage. We don't know, because this docket does not say. Some dockets will say, but this docket does not say. It looks like 2 of his requests for subpoena were not approved. Okay, tear it up 687.5. Thank you for the super chat. Is it true that the jury was released for a day before the verdict was given? No, but let me show you what did happen, and I'm going to go to that. And then I'll back up to bringing everybody up to date. Let me just find. The question was, I'll tell you what the day gap was in there. The question was, is it true that the jury was released for a day before the verdict was given? No, I believe they went after the last witnesses and the closing statements. They went into deliberations, and then they came out and gave the verdict. But let me show you. Am I sharing? Here I am. Let me just. Sorry, I'm still new at this. Okay. Let's go back. Now, this is the trial court docket. Okay, so where the people left, the defense rested its case, and then everybody went home, and that was on the 8th. And then on the 9th, when they came back, the verdict, the deliberation instructions were read to them. They had their closing arguments, and the jury went right into deliberate. You can see that right here. Okay, so what you're talking about, I think, is the defense rested its case on the 8th, and then everybody came back on the 9th. They did their closing arguments. The jury was sent to deliberate, and the jury came right back out 3 hours later. They gave the verdict of murder, and then on that same day was the punishment, the case and punishment, the entire thing, and then this is all on the 9th. I'm going to the next page, still on the 9th. The verdict was given. And the sentence was given. the verdict and the sentence. So no, all of this happened on the same day. And the other thing is, and again, the transcript will show this, but I was under the impression, I don't know if I heard it on the news or from one of the trial watchers, the jury was told that they would be sequestered as long as they deliberated. Now, when we go back, right, so they had not been sequestered for the whole trial, which means that they were watching the news. They were told they're not supposed to, but of course they were. They were watching the news. They were talking to their friends, even though they're not supposed to. And then when they came back on the day they were sent into deliberations, now, mind you, they had almost a full day, they were definitely in the afternoon when they were released to go deliberate. And they were told that if they didn't come to a decision, to a verdict, they would be sequestered. Now, if they had been turned loose at 9:05 in the morning and told that they had until 5 o'clock, and if they didn't come up with a decision, they would be sequestered, that's one thing. But to tell them at lunchtime that if they don't come up with a verdict, but in the next 3 to 4 or 5 hours, they're going to have to spend the night there, that's putting a little bit of pressure on the jury, if you ask me. That to me is shady, and that to me could be grounds for a new trial right there. Because when we just looked at the rules of granting a new trial, one of them two of them touched on sort of pressuring jurors to behave a certain way, right? So, but anyway, to answer your question, no. The gap was between the end of the defense resting its case, and then they came back on the 9th, and they did their closing arguments, and then the jury was sent to deliberate. And they deliberated, found the verdict, heard the punishment stuff, and then issued the sentence all in the same afternoon. Court didn't even run late. That's crazy. Thank you for the question. Oh, I was updating people on what else we saw when we went through the trial record. Okay. So after what's this guy's name? Mike Howard comes in. He's the third attorney. He does some a quick blitz of requests for subpoenas. We saw that 2 of his subpoenas don't appear to have been approved. We don't know what the subpoenas were for or why they did not get approved. What it looks like is that the prosecutor's subpoenas were all approved. If there is something there, or if what was not approved was significant or potentially material, this appellate team will find it. Okay. So then we heard nothing from the defense until really about a week before, or less than a week before the trial started. But in that time, we saw the prosecutor apply to have an expert witness admitted. That was approved. There's no indication here that it was moved to a different county. So I heard people say that it should have never been in Collin County. There's no indication in this record. I'll say that there's no indication in this record that there was any request that it be moved to a different county. And that is something that would be in here, right? And then we would pick it up in the county of another courthouse, right? We would pick the docket up in the new county. There's nothing here about any request for a change of venue, nothing about the defense trying to get expert witnesses in, no motion for recusal. We don't see any of that in this docket. And unless things are being hidden from the docket, sealed from the docket, which happens in the most rarest of circumstances, are parts of the docket sealed. And there's usually an indication that something in the docket, something else exists in the docket that has been sealed or is under seal. You might see that language, that whatever this motion is, or whatever this activity was by agreement of the parties is not in the docket. We see no reference of it. Okay, so that might be a myth. So anyway, so in this time, we see in the time between the very beginning when Mike Howard first comes on and 1 week before trial, right? So there's many months in there. He's relatively quiet. We see the state request. We see the state request expert witnesses and get approved. We see no defense requests for expert witnesses. And expert witnesses, you guys, unfortunately, are not hard to come by, right? People say, well, what if there were no expert witness? You can find an expert witness if you want one, right? And then what happens is it's up to the jury to decide how credible the expert was. But you can always find an expert, okay? So then the next sort of incredible thing that we see is that literally within 4 business days, where's my calendar? Where's my calendar? Do I have one nearby? Let me see. On what year is this? 26. Okay, let me see. On May 26. Hold on, I'm pulling up the calendar. Oh no, May 26 was Memorial Day. May 26 was Memorial Day. Okay. So there has been, I see someone saying that it didn't happen in Collin County. Frisco, Texas is split between 2 counties, Collin County and Denton County. The majority of the city lies within Collin County, while the westernmost portion extends into Denton County. So let me ask. Okay, so can that just be the end of that? People keep saying that the county's not right. There's no indication in here that there was any request for. All right, let me. I'm looking, is the. Okay, the Frisco Independent School District venues and stadiums are primarily located in Collin County, Texas, though a portion of the school district does stretch into neighboring Denton County. Let me ask specifically, where is this Kuykendall Stadium? Because this seems so easy to get out of the rumor. There's still a lot of rumors that we can't answer, but this one is fairly easy. Let me see. The Frisco ISD David Kuykendall Stadium is located in Collin County, Texas. Okay. David Kuykendall, I'm on a website called Texas Bob. I don't know, Stadium. David Kuykendall Stadium, owner, Frisco ISD, County, Collin. All right, so let's let this go. Let's stop feeding that particular myth and using it to imply that there's some kind of malfeasance or something going on, right? I just read 3 or 4 different places. They all said that this stadium is in Collin County, and that Frisco, Texas overlaps 2 counties. The majority of it is in Collin County. The westernmost edges are in Denton County. Okay, so let's let that one go. Okay, so what I was saying was that the incredible thing is that, so I pulled out my map. The incredible thing was that on May 26th of 20, oh, I'm sorry. What year is this? Okay. Let me go back, y'all. I grabbed the wrong calendar. That was 2025. Do I have a 2026 calendar? Y'all, what day of the week is, let me see here. I'm literally opening up a calendar book. Let's go to May 26th of 2026. That is ridiculous. That is the Tuesday. Let me check the year. May 2026. They submitted 16 applications for subpoena, the defense did, on Tuesday, May 26th, the day after Memorial Day. They were approved on that day, and the trial started 6 days later on Monday, June 1st. There is no way that if those applications were approved, there was no way that that defense attorney had the time to receive all of the information in 16 different subpoenas, process it, strategize around it, and be ready for trial in less than 7 days. There's no way. So that right there, either he's playing chess, like I said, or he's a fool, and I don't know which is which. I don't know. It's definitely like I said. Now, if he was really trying to win the retrial and not the trial, and if you haven't viewed the chess versus checkers video, you need to go watch that, because I break down the whole strategy of why a defense attorney might not throw a case but sacrifice a trial to win at the appellate or the new trial level, to try to get a new trial. I break that strategy down. It's very risky, but it's a real strategy. Okay. And if that's the case, he would have filed those subpoenas at the last minute with no intention of ever using or processing or including that evidence. All right. So that's really all I have, you guys. I wanted to walk you through line by line so that you could see and decide for yourselves, see what I see. What I see is that the defense counsel may have either gotten outmaneuvered massively, did not have the resources and the support that he needed to put on this case, may have been outfoxed, may have been out of his league, may have been in over his head, I don't know. Or he was sacrificing at the trial level so that these people would pick up at the appellate level and try to get a whole new trial. I don't know. And I don't know. That's all I got. If anybody has anything that they want me to see, because there's a lot of stuff here, we should get a petition together for them not to edit no evidence, period. All originals need to be seen by all parties, and they edit it together, but as long as the whole original has been seen. Yeah. In order to know what the whole entire footage was. Now, this doesn't even get into, and I'm going to get into this when I do my live about whether or not the prosecutor turned over information, right? This does not even get to the potential cell phone evidence that the students might have had. Now, if they were successful in suppressing all of the student footage, which, if those students were sitting under that tent and there was a rain break happening, you know they were sitting there on their cell phones. They had them in hand. They were texting each other. They were on the phone. They were playing games. They were watching TikToks, and right. If they were really sitting under a rain break, for a rain break, you know those kids had their phones in their hands. So I will say this: if the school or the prosecution successfully suppressed all or made vanish all of that evidence, the only other defendant that I've ever seen, the only other institution that I've ever seen with that power is Disney. Disney. Accidents and incidents happen at Disney all the time, every day. You never see footage come out of that park. People get harmed, people get assaulted, people get legs cut off, people get all kinds of stuff. You never see footage come out of Disney. Nobody knows how they do it, but their stuff is ironclad. Their security, they say they have people within 45 seconds of any incident that happens, right? They have undercover people, they have teenagers, adults, people in wheelchairs, they have workers, they have everything. A Disney employee is, and this is a sidebar, a Disney employee is never more than 45 seconds. I've heard in the legal community, this is like legend, I mean. They have a person to respond to any incident within 45 seconds, people come out like they come out of everywhere if something goes down. I don't know. If Frisco pulled that off, that is some Disney level maneuvering, but time will tell. We will see. We shall see. All right, you guys, if there's nothing else, so let me just answer this, because I've answered this in a couple different ways, but let me just say, someone say, Counsel Gray, why can't they just get the original whole tape? And they may very well get to the bottom of it, right? They may be able to pull off things that Mike Howard alone could not pull off. Okay. They put 6 heavy hitters on, and their firms, right, on this appeal because they understand the work and the legwork that goes into something like this. Mike Howard probably just could not do it. He probably just didn't have the legwork. But here's the problem. Again, there are so many levels and so many places where that footage would have been cut, okay? Potentially could have been cut, because whoever was operating the camera that day, and yes, I know they were up on a pole. Yes, I know that they were probably stationary cameras, right? They clearly were stationary cameras. Any movement that you saw in the footage was somebody after the fact zooming in and moving throughout different parts. I do not believe, and I know that people in the comments do believe, that there was somebody who chose in real time to follow Karmelo, chose in real time to follow whatever. I don't believe that. I believe that there was the footage from stationary cameras, and then after the fact, somebody, and we don't know who, somebody went in and moved, maybe with like a mouse or a pen or something, moved through the footage and only played certain parts of it. That's what I believe. But anyway, the person who was in charge of the actual footage, the actual files, then there would have been their boss, the head of security. Then there would have been the school district's legal team, right? The Frisco ISD Department of Law or legal in-house department. Then the footage, okay, so it would have gone from the camera, whoever was in charge of the cameras, to the head of security, so that's a second person, to the legal department, that's a third person, to the prosecutor, and then what was introduced into court. So 5 editorial decisions were made before the evidence was entered into court. We have no way of knowing based on what was released to the public. And where did that happen again? That happened right here. Right? This is the page on the Collin County website. This is the page where all of the exhibits were released. 5 different sets of hands touched and edited this information before it was offered as exhibits and then released to the public. So now other exhibits that they could have released but didn't is the witness list, the transcripts, recordings of testimony, right? None of this stuff is out yet. None of this stuff is out yet. If it's ever going to come out, we don't know. So yeah, that's why we can't just get the full thing, because even if some footage was hidden, we don't know who hid it. The appellate team is going to have to get to the bottom of this, right? And they're probably going to have to use some kind of AI to put in, to backtrack all of the cuts in that footage, right? What's the difference between this footage and this footage? And then let the AI tell them, oh, this part was cut out, this part was sped up, this part was slowed down. So that's that. To answer your question, that's why we don't have it yet. Okay. Aaron Hughes, I love you, Counsel Gray. Oh, thank you. And I will support your channel soon when I get paid. And you deserve every bit of super chats. You have the best coverage, hands down, on this case. I appreciate you. I appreciate you for that. Thank you. Gray is awesome. Thank you so much. Okay. Jasmine Crockett is probably involved. Hopefully she made some well, let me say this. Everyone always says, well, why didn't this person get involved? And why didn't that person speak up on this, that, and the other? Sometimes we have to show grace to these people, because sometimes For them to speak up on one thing could sacrifice the bigger thing, right? And so Jasmine Crockett did speak up on this Karmelo Anthony thing. And her detractors used it to totally obliterate her. She is worth more to her district and to the culture than to make a comment on one case. She doesn't have to, right? And you can cause a person to get completely sidelined because they spoke up on one controversial issue and takes them out of the larger conversation. So when we don't hear from people, we have to assume, we can't just assume that they don't care. Sometimes the bigger fight is more important. That's it. She ran a big scam to get into office. It's a whole ordeal. I'm gonna let you guys in Texas figure that part out. But I'm just saying, like there are some people, like I heard someone saying, where are all the athletes? What is it with our culture and athletes? I don't get it. Where are all the athletes? Where are all the entertainers? Why aren't they speaking on Karmelo Anthony? Are they lawyers? Are they cops? Are they, I mean, like, I don't, you know what? Let me not even get into that. All right, you guys. So unless you guys have something else. All right. Someone said, Council Gray, why do you think they, where'd it go? Why do you think they allow people to go up to Frisco ISD to see the videos? Because Texas probably has, maybe the state of Texas or that county has a public records law where things that are owned by government agencies are actually considered to be owned by the state, by the public. And then they may not want to release it because it may have come before or after the gag order. There may be pending or upcoming litigation. They may not have wanted it to get dissected in the news before the trial happened. So what they do to be in compliance with the public records laws is they create an opportunity for people to come in and view it on a screen. And oftentimes when that happens, and that's very common, the people are checked for recording devices and they're not actually allowed to touch the thing. It's allowed to play because the public records law only requires that people be able to see it. It doesn't require that they be able to stop it and slow it down and back it up and, you know, maneuver it themselves, right? So what they do is they may come in at a certain time, they make an appointment, they come in and someone puts it on a monitor and hits play and they can see it like that. So that's why they got to see it. And that's also why they had to see it in that setting. Okay. Yeah, the Freedom of Information Act. That's exactly right. The Freedom of it's a category of laws, and most of the states have them, where anything that's owned or paid for by the public can see it. And that extends to records of public meetings, the minutes, public camera videos, traffic cameras, cameras of intersections, anything that's public and is paid for by the public has a right to see under various public records laws, and they're called different things in different states. But it doesn't mean that you can retain it. It just means that they have to allow you to see it. Doesn't mean that you can control it. Okay. Oh, thank you, Counsel Gray. I wish you had been his defense attorney. I don't hear bias in you at all. Thank you. I try to tell you guys what it is. And some of this stuff, you know, some of the rumors that are persisting, we can shut them down so that we can focus on, we're more effective when we focus on what actually happened, right? So the sooner we can strike down some of these rumors, the more we can concentrate and focus our attention on the things that are still shady. What county this in is so easy to check, right? I just checked it in four different sites, and they all said that it is Collin County. So now we can put that one to sleep and let it go. Tents at a public school with taxpayers' money. They don't say ownership of space. Yeah, so I'm inclined to agree that any Any reason that he should not have been there is more custom than it is the rule or the law, because because they don't own that property, they don't actually have the right to exclude people from it. That's custom and courtesy, I think. Now, you may find that after this incident, when the sports association or authority or whatever, the Frisco Sports Authority or whatever, they may rewrite their rules to say something like that. That once a school has claimed a tent, it's intended only for the students of that school. A lot of rules get changed after cases like this. So I would not be surprised if we see a lot of rules in that county, in that school district, and in Texas change as a result of certain cases like this. Okay, so the other thing that we saw, in case you weren't here when we did the appellate docket, we did see that, as I predicted, the very first thing they did when they filed their appeal, with that, they also filed a motion for a new trial and a motion to have Judge John Roach Jr. recused. They don't want him deciding. So the motion for a new trial is made to the judge who just heard the previous trial. So the chances of that judge saying, hey, you're right, I did botch this case, let's do it all over again, right? Let's spend another couple million of the county's money to re-prosecute this. They're going to obviously say no. And so the defense's appeal, they asked for the new trial, absolutely, and that the judge be recused. Now, he can be recused both from deciding on the motion for a new trial. Instead of going back to that same judge, he would recuse and would go to somebody else, and recuse him from hearing the new trial if the new trial is granted. Now, if the motion to recuse, right, because again, I also talked about this in another video, judges decide for themselves whether or not they believe they should recuse themselves, right? You can ask a judge to recuse himself, and the judge can say, no, I'm not going to recuse myself. And that, even if he knows one of the parties, he doesn't have to recuse. Even if they used to be neighbors, even if it's a family member, they don't have to recuse. They can say, well, yes, that's my cousin, but I can still be fair. Or yes, he's a golfing buddy, but I can still be fair. I don't choose to recuse myself. There is a higher level. You can appeal the judge's refusal to recuse. But right now, they're at the level of a motion to recuse. Why a judge might ultimately recuse is because they don't want everything that's going to come after it, right? So right now, they are making a motion for the judge to recuse and a motion for a new trial. Chances are the judge is going to reject both of them, at which point the appellate court may have to weigh in on that. So, I mean, it's crazy. There's a lot of reasons in the jurisprudence of it. There are reasons why a trial judge is the decider of whether or not to issue a new trial and whether or not to recuse himself. There is jurisprudence about that, but right now that is the way it stands. You're basically going to ask Judge Roach, hey, Judge, can we get a new trial? Let's redo this whole thing, Judge. He's already said that he's happy with the outcome. He already said that he thinks the right thing happened. He already said that he thinks Karmelo was a good kid who did a crime, right? You guys remember that from the interview? So, but that's the procedure for right now. And then, hey, Judge, why don't you just go ahead and recuse yourself? He's going to say no. The appellate court will weigh in, and they may remove him from the case, and they can override his refusal to grant a new trial, or they can affirm, right? The appellate court can say, we affirm his decision not to do a new trial. We'll see. Okay. All right. Yeah, someone said a judge's refusal to recuse himself, it seems like policing each other or policing themselves. Well, either or, right? Policing each other or policing themselves. It's a huge problem. But there are reasons for it, but it's a huge problem, well-known problem. Briefly, the problem with it is that it creates one more thing that they have to, one more relationship that they have to manage, and one more thing that they have to be thinking about when they grant their verdict. or their sentence or something, or how they conduct, right? If they have to also be worried about one of their colleagues coming in and reversing, now they're not just performing for the appellate court, now they're also performing for one of their colleagues who could overturn the whole thing and blah, 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 right? Also, I mean, judges are on the bench for a reason. Somebody wanted them. Either the electorate wanted them or the governor wanted them. And so people are deferential to the trial judge's decisions unless they're proven to have an error. But we don't just go turning over people's trial judges' decisions for no reason. Obviously, they do get turned over, but the courts in the appellate process are deferential to those trial court decisions. All right. And yep, someone put in the comment, who wrote that? Aaron Hughes. Vote Counsel Gray for Texas judge. I saw, yep, vote. I saw the word vote. I didn't even see the whole thing, but thank you for that. You guys, it is important to vote. And this is a great point. Thank you for bringing this to my remembrance. It is important that you vote because this judge was elected. He is a demonstrated staunch Republican judge. He was elected. Where were the voters, right? People think you only have to come out and vote for the president if the weather is good. But no, you have to vote for these judges too. The people of Collin County put him on the bench because people don't come out, right? I've seen mayoral elections in certain cities where the mayor got 1,600 votes in a U.S. city because people in that particular city did not come out to vote for mayor. 1,600 votes. I've been to a wedding with 1,200 people in it. I mean, not in it, but at it. I mean, 1,600 people is the number of kids in the cafeteria in a big high school. 1,600 people. I mean, that's the number of people on one level of the mall. And you've elected your whole mayor because people don't come out to vote. So yes, you got to vote for these judges. You got to vote for these judges. All right. So I'm going to stay on this case. This process could take potentially a couple of years, definitely a year, you know, maybe two if it goes super duper fast, which I don't know with this dream team, who knows what's going to happen, y'all. This is going to be really good, you guys. I'm going to stay on this case. So that's all I have. That's all I have for this. If there's no more last minute questions, I'm going to Yep, district attorney and criminal appeals courts vote in November of this year. I didn't know that. You guys, if that's true, go and vote for these judges. Go and vote for this district attorney. All right, don't miss these little. This is a great example of what happens when you don't vote in these little tiny elections that you think don't matter. Or, you know, some of these judges get in with very, very few actual votes because nobody showed up to that midterm, whatever, that off date, you know, whatever election. All right, you guys. So that's all I have. For those of you that have stuck it out, I appreciate you. For those of you that have jumped in, I've recapped everything. The main thing is that we don't see that Mike Howard applied for any expert witnesses. We see that in the very beginning, when he first got hired, he put in a couple of subpoenas. At least 2 of them did not get accepted. And then the next time we really heard from him, he put in 16 requests for subpoena, and they got approved on the Tuesday before the Monday where court started. So he was giving himself 4 days to request the information by subpoena or the testimony, process it, come up with a strategy, organize it, change his trial strategy if necessary, and then start working. Impossible feat. Unless he knew he wouldn't win and he just wanted to get them on the record and never intended to use whatever he got so that it could be, you know, prepare people for the retrial. I don't know. That's the chess v checkers. Okay. So, thank you, Justice, for coming. So that's all I'm going to say, you guys. Most likely on Tuesday, I'm actually going to the beach for vacation. Most likely on Tuesday, I will come back and I have a banger for you guys. It's about what happens if the prosecutor did have evidence that they did not turn over. A lot of people are convinced that that is the case. I don't know. I'm just going to tell you what would happen and where the footage especially could have been chopped, why that person might have chopped it up, and what could happen to all of those people if it comes out that something that was exculpatory to Karmelo, meaning would tend to show that he did not do what they're saying he did. If they cut out anything exculpatory, I will show you all the way down the line who could have done what, why they might have done it, and what will happen to them. So, all right, you guys, thank you. Someone said jail. We'll see. I'll tell you all about it on Tuesday, probably, depending on how it goes, because I'm going on vacation, a short one. All right, you guys, thank you.